Aloha and welcome to Condo Insider, Hawaii's show about living in an association. I've often said at the beginning of this show about a third of our population lives in an association, but recent statistics show it's about 38% of our population lives in some form of common interest real estate association. So it's a lot of things very important in that because you have to make sacrifices, and you have to learn how to abide by rules so everybody can live in harmony together. One of the things that we've seen that's been a real topic of interest and debate lately, and it's the number one complaint with the Regulated Industry Complaint Office, is our condo statute provides that owners are entitled to certain documents. And it actually is the number one complaint RICO has in the condo world anyway, from owners saying they have a hard time getting association documents. But as in anything, when laws are written, there's a lot of grayness and misunderstanding and overreach. And we have today visiting us, and I ask her to come back, one of our great local attorneys, Lan, who works for Mota, Oka, and Rosenberg. And I wanted to talk with her today about what documents the owners are entitled to and have a discussion about this, because certainly living in a condo, people are owners, they have a right to a certain amount of transparency to know what's going on. But the converse argument is an owner with an agenda could misuse that information and cause liability for an association under certain cases. So let's start with the basic things. Mm-hmm. Welcome, first of all.
Thanks for having me back.
Yeah, tell us again a little bit about your firm and you.
So I was graduated from William S. Richardson School of Law from UH, and I have been, since my graduation in 2009, I have been representing associations in Hawaii. My practice basically includes general matter consulting, collection, foreclosure, and also do all their general matter, like contract review, their project, covenant enforcement, all kinds of legal matters for associations. Our law firm is a boutique firm focusing on association practice. We have 7 attorneys representing over 300 associations all over islands.
And do you find working with condo boards challenging?
It's challenging and interesting as well. Yeah.
What do you find the most challenging part about it is?
I would see, the board is always kind of in the middle because you have owners sometimes, they are like having their own agenda, trying to making all sorts of claims, and they didn't realize, the board is actually also owners, just volunteering for the association, doing all this, work for the association without any compensation. But oftentimes owners tend to complain or blame the boards, and without realizing, this board has been, doing all these community service for their project.
Yeah, my experience has been that condos, particularly the boards, they have a limited amount of income paid by the maintenance fees. Mm-hmm. And so when people want changes, there's a price tag to that sometimes. And people don't realize it's really the owner's price tag, and boards try to do the best they can by managing the budget and keeping the costs low. But sometimes surprises happen, which makes it difficult for owners and boards as they have to raise the fees. But let's go back to condo documents. Mm-hmm. Are owners entitled to documents, and why?
Yeah, so the condominium statute in Hawaii, 514B, they have several sections. That would be section 152 through 154.5. They all provide obligations for the association to maintain records and provide those certain records to owners upon request. And if your association is incorporated, then the Nonprofit Act 414D also requires the nonprofit corporation to provide documents to its members.
Now, are they required to give any document or all documents or everything, or is it limited to certain types of documents, and what kind of examples do you have?
It's limited to certain types of documents. For example, any financial records that's relevant to a resale of a unit. Like, for example, budget, reserve study, most current financial or the financials for the recent years, and definitely relevant. The association's project documents, declarations, bylaws, house rules, or if there's lease conversion, all those documents, public reports. If it's incorporated, then of course incorporation documents, annual reports, those are relevant. Other important stuff is membership list. Others like meeting minutes for board meetings or association meetings. Those would be the examples, and sometimes also include contracts of associations, invoices on maintenance and repairs for the common elements.
Well, I think the law was pretty clear on what documents. I know another set of documents that is after an annual meeting, for example, the law provides for 30 days they can get can review the proxies and the voting tabulations to see who was voted. And I think that's limited to 30 days following the meeting.
Yes, if there's no request coming in for those kind of records, the association can actually dispose of it. If there's a request coming in, then they have the obligation to keep it for additional 60 days, and the board would have to provide it if a request comes in.
And from my experience, most management companies keep them for a couple of years. Why, I don't know, but most of them keep them longer because there's really no harm in keeping them longer. What sometimes people don't realize under Robert's Rules of Order, that even when you have a mistake in counting and balloting and whatever it may be, and that gavel falls and within the meeting someone hasn't raised the point of order challenging the election, that under Robert's Rules, that election basically stands, or that vote basically stands because there was no challenge. And to overturn that within 30 days of an annual meeting, the standards are very, very high to do that. It's not something that you can easily do because it's just part of the process and within Robert's Rules.
Yeah, and it's a good idea. I agree, it's a good idea to keep it, especially in the electronic age. The managing agents also have statutory duty to keep records for a certain period of time.
Most of the concerns I see from owners when they're requesting something is what we call written agreements, contracts. They're entitled to all written agreements or contracts under the statute. And what comes out of that is an owner will say, I want the general manager's contract. And that contract may have social security numbers, may have privacy information about his wife and children, it may have addresses and cell phones. And how do you balance that? Is there a rule of thumb for contracts on what a board should do when they get a request for a general manager's contract? 'Cause I know there's different trains of thought on this, but let's just chat about it.
Yeah, it is still like a gray area. There's like no solid labor law or employment law authority on this. But generally, the association has rights to redact certain kind of information. Although the condo statute is silent on this issue, I think the Planned Community Association statute 421J in Section 7 actually pointed out certain information that the association can withhold it from our owners. Example would be personnel information, like as you said, social security, there are sensitive personal information, like medical records, like if somebody provides information to get a reasonable accommodation, apparently those kind of information, you shouldn't just release it to other parties. Also, certain laws actually prevent the association from disclosing certain information. Let's see, owners' delinquent records. Actually, the Fair Debt Collection Practice Act prevent a party from, a creditor or a debt collector from publishing a list of members who are delinquent on association dues. It's okay to have a monthly statement of the total amounts of delinquency, but you cannot list specific names of other owners who are delinquent and provide that to another owner. That's not allowed.
Yeah, I can see the issues because when you look at a owner who may have a gripe against the resident or general manager, and he wants to see the personnel file. First of all, that owner may be, maybe he had a drunk driving conviction, or that resident manager may have had a drunk driving conviction 10 years ago. And that's a protected class under Hawaii employment law. You couldn't, unless there was some reasonable basis, like you were hiring him as a truck driver, there's no basis to deny him. And with social media allowing a lot of this stuff to get out would be putting the association in harm's way because their job is to follow the law and protect that person. And so there's a lot of information out there that may not just be appropriate to share.
Yeah, I mean, if there's other ways you can figure it out instead of through the association, the owner, as a member of the association, you should also consider, whether your request is going to expose your association to potential claims by other parties. Because ultimately, maybe today you are on the requesting end. Some day later, you could be the person whose information may be in jeopardy if another person wants to probe into your file. So the board is really in the middle to try to, balance, to protect, everybody's interest and for the best interest of the association and all its members.
Yeah, I know also another thing we saw is that sometimes an association will employ 3 landscapers. Maybe one makes $10 an hour, one makes $11 an hour, one makes $12 an hour. and you have 3 great landscapers. Do you really want your association next door knowing you pay one gardener $10 and you know he does a good job, so he's now going to that gardener and saying, well, I want to hire you and I'll pay you more money. You know, if that kind of information gets out, that's harmful to the association, right?
Yeah, exactly. You know, association is also employer. You know, we all know in workplace it's not a good idea to publish everybody's salary to all the employees. Same thing would apply to the association. And a similar, you know, analysis would apply to for Bs or contract that are still in active negotiation. You know, under that statute I talked about, 421G for planned community association, that's also allowed to be withheld from owners.
I should say, you know, from my experience, I've talked to RICO, and I've also talked, that's the Regulated Industry Complaint Office, for those that don't know, who enforces the law with respect to document production. And I've talked to our legislators, and they basically have said orally that they take the position that certain personnel information obviously can be redacted: social security numbers, private cell phones, addresses. These letter agreements on your landscapers at $11, $12, and $13 an hour obviously don't have to be given. You have a financial statement you can get which gives you kind of the cost of landscaping for your association. But they take the position, the number one person, the general manager, the resident manager, that owners are entitled to the compensation, any bonus plans, and what the job description is of that manager for the compensation. And that's what they take as the provision. I know coming up next week, there's a Act 187 mediation where an owner has requested that document, and the contract came back 90% redacted in black with very little information. And in all cases, everybody agrees that the social security number, the private cell phone number, that type of medical, you know, any prior criminal complaint thing on that level I just described does not have to be disclosed. You know, so the issue is compensation, and the issue is job description, and any bonus plans that may exist. And you know, I was talking to, because the law is pretty clear. If I read the law, it says you're entitled to all contracts. It doesn't say you can redact, and it doesn't say employment contracts are excluded. But then I had an employment lawyer say to me, was a contract an employment agreement? I don't know what he meant by that. To me, employment agreement is a contract, you know, in the broad term anyway. Maybe in a legal term it's not.
Yeah, there's really no black and white at this point. I would think, you know, the guiding star should be whether this is for the best interest of the association and all of its members. You can't just really have like a clear dividing line, you know, depending on the circumstances. You know, think about it. If you're in a nonprofit corporation, you're one of the members in the corporation, then of course you would want to know, you know, how much the director is being paid, or the officer in charge, the CEO, or what his compensation is, because obviously you are paying for his compensation. You have an interest in knowing that. Also, like for job description, you know, sometimes the owner would want to know whether, you know, the employee of the association has been fulfilling the job duties, you know.
Well, it's a difficult balance, you know, because owners are stakeholders, they have a right to know, but at the same time, the release of improper information publicly could create harm to the association. And people get worked up, they don't always realize that, and I think the board has to balance that. We're going to take a short break. We're talking with Lan about what documents owners are entitled to under the state law and some of the gray areas, and we'll be right back.
Hello, I'm Marianne Sasaki. Welcome to Think Tech Hawaii, where some of the most interesting conversations in Honolulu go on. I have a show on Wednesdays from 1 to 2 called Life in the Law, where we discuss legal issues, politics, governmental topics, and a whole host of issues. I hope you'll join me.
Hey, Stan the Energy Man here. I know you're bored this summer. You're just sitting at home, figuring out what to do, go to the beach. Spend some time with Think Tech Hawaii. Spend the time thinking about how you can contribute to Hawaii and making it a better place to live. And start watching some of the programs on Think Tech, including Stan the Energy Man, where you'll learn all about everything energy, especially hydrogen and transportation. So we'll see you every Friday at 12 o'clock noon. Stan the Energy Man here on Think Tech Hawaii. Aloha.
Hi, my name is Kim Lau, and I'm the host of Hawaii Rising. You can watch me live every other Monday at 4 p.m. Aloha!
Hi, my name is Aaron Wills. You are watching ThinkTechHawaii.com. I am the host of the show Rehabilitation Coming Soon. You can watch us live at thinktechhawaii.com at 11 a.m. on Tuesdays. I will see you there.
Welcome back to Condo Insider. We're talking to prominent attorney Lan about the law and what owners are entitled to as far as documents of their condo association. Before we took the break, we were talking about employment law, but I know the statute, we said they're entitled to financial statements and minutes. And what about other documents? I think the law refers to, quote, other documents. That's kind of a broad, general kind of a statement. What happens then?
So those owners have to send a written request. Basically, there's actually a form published by RICO, through DCCA. It's not a mandatory one, but if owners does not know how to, write a written request, they can simply use this form. It's a 2-page form, like just filling in POCAs and then send it to the association. And then upon receipt of this request, the association has 30 days to respond, with the exception of meeting minutes, because there's a specific statute regarding meeting minutes. There's a 15-day actually rule, so that's a little bit different there. So then, of course, I was going to just emphasize that if there's, of course, pending litigation or other legal issues with the association, one of the principles that will kick in is attorney-client privilege or attorney-work product. Those kind of things would be protected. The association, the board should be cautious about releasing those. You should always check with the attorney first.
And can the owner be charged for getting this information?
Yes, the association can charge reasonable, administrative charges or copying charges, and there is actually a ceiling for the charge, which is $1 per page.
So that's the ceiling.
Yes.
Now, having been in the condo business before, what I found was frustrating at times is owners get frustrated and they want information. That's okay.
Yeah.
But they'll write and they'll say, they'll look at the statute and they'll say, I want all of the financial statements, all of the minutes, all of the records, all of the contracts, all of the bids since the year 2000 to present, and then they'll sign it. Now, what they don't realize is that that's thousands of pages of documents,
Yeah.
And it's important that when owners fill out that form to really think about what they really want and pick the dates and the years and the terms and define it well, because what frustrates management companies on the other end is they don't take the time to think through what they want. They can always make second and third requests, but they more times than not, we get this broad-based request that says, I want everything I'm entitled to by law since the year 2000, which is thousands of pages.
Yeah.
And the alternative is they can say, I want to inspect those records.
Yes.
And come down to the office and go through them themselves and avoid that. But most times they say, I want you to give me all of these records. And most management companies come back and say, well, we need a deposit of $2,000. And they come back and they say, can you refine that request? And they get upset like we're trying to stall. But you can see the problem that management companies are businesses too. It takes time for people to go get the records, retrieve them from storage, maybe if they're old.
Yeah.
And to copy them and put them back again is not inexpensive when you get these broad-based requests. So
Yeah, there's actually another statutory provision in a different section of the 514B condominium statute. Basically says the association and its managing agent can actually send a written notice to the owner 10 days ahead of incurring any charge related to trying to retrieve those documents or making copies. Basically informing the owner that, hey, this is your request, it's gonna cost you this much of dollars, and can you confirm whether you want it or not? Then the association send the request, then the owner has a right to decide whether they want to withdraw some of their requests or try to narrow it down, or confirm, oh, I still want it, I'll pay for that. Then on top of that, association also has the right to, require like affidavit for the purpose of use of those documents. Those are the requirements the owner should be aware of when they send in requests.
So the affidavits basically say, I want these for association business. I'm not using it for my marketing and sales list on my own private business. That you're basically attesting to the fact that you want those for association business, such as soliciting a proxy or soliciting a vote for or against a bylaw, something along that line.
Yeah, especially for a membership list, that has all the names and addresses of all the unit owners. So that affidavit has to say that, you're using it only for the purpose of soliciting proxies or votes for association matters, cannot be for any other purpose. For all the other documents, requiring affidavits, basically the affidavit would see, you are requesting these documents in good faith for the interest of the association or to protect all the interests of the association's members. Cannot be used for your personal agenda against the association to harm the association's members. Yeah.
And it's my belief also that they're entitled to a mailing list. And that doesn't mean that the management company is giving them the phone numbers or the email addresses. They're getting a mailing list only.
Yeah, emails and cell phones, those are still private. You cannot just disclose those to.
Yeah, because people are entitled to privacy.
Yeah.
Just because someone may want your vote, want to solicit you, they shouldn't be affected by having that person sending them constant emails and calling them on the phone. In fact, every year in the legislature, I shouldn't say every year, but in the legislature, we often see bills that come forward saying, make email lists available. And the industry, as well as many owners and boards, resist it because they're volunteers, they're private people, they want to be able to enjoy their life. And what happens is people who really get excited about something will send barrage amounts of information and phone calls. They'll tell their 10 friends who agree with them, you send an email, you call them. So that owner's list is unlimited to a mailing list. It's not includes email and the phone numbers.
Yeah, you're correct, Richard. I mean, that's also for security reasons. These days, like cyberbullying, like invasion of privacy, it's pretty common with cell phone numbers, with emails, because that's very intimate. Everything is hooked to your phone. A smartphone is like another you, basically.
Another request I saw recently was an owner said, I want you to go to the insurance agent and get me a written report by year for the last 10 years of all the water damage claimed and how much was paid out by the insurance company. That record doesn't exist within the association's normal business records. Does an association or the management company have an obligation to go produce a report that doesn't exist, that's not part of the business records? Or is that something that they don't have to do?
The association does not have the obligation to try to create or produce something that's not in their business records. But the association owner actually can have the option of inspect all the association's records, try to piece them together, come up with his own summary or report that he wants.
So he could go and inspect them, get the files to what they exist, but at the same time, in this particular case, you're talking now about a third party, the insurance agent, and they have a relationship with the board. I don't believe that most agents would let the owner come in and say, I'm going to produce this report to you. They're going to be limited to the business records because people who, I should make it clear, I believe in transparency. Owners should be entitled to any record that doesn't potentially put the association in harm. And they certainly, when you look at some of the requests we get, we see that they don't see that. I'm going to give you just a couple examples and so our viewing audience can understand. A couple of the requests I've got is, Richard Emery, want to know about Lan's ledger, whether she's making her payments on time, and whether she's delinquent, and whether you sent her any letters, or whether she has any house rules fines against her. Now, it's not about me, it's about you, who's another owner, and I may not like you, and of course I love you, but the reality of it is, most people say they're not entitled to that, even though it's an association record, because it's not their ledger.
Yes, and there could also be like fair debt collection practice violation issues for the association. So that's definitely not something we would,
See, another request we got was, I want to see the bank signature cards when we as the management company open the bank accounts, and whose signatures. I want copies of that. And the problem is, in this electronic world today, you can steal signatures. If you have account numbers, you can create all sorts of havoc. And so the law doesn't say you're entitled to bank signature cards. And so they would make the request to the board under the other document provision, and probably the board would say, we believe that puts us at risk because signatures can be stolen. There's no valid reason for you to have that document, so we're not going to give it to you.
Yeah, I mean, that's definitely a cybersecurity justification there. Sounds like you got all the tough projects.
Yeah, well, I put together a list of the 25 most common gray areas in the law. And as an industry, we're working with RICO and the legislature, and our goal is over the next 12 months to get everybody on the same page, because what would be helpful, we think, to the industry is if there's clarity what you're entitled to, what you're not entitled to. If everybody's in agreement you're not entitled to another owner's ledger for all these reasons we stated,
Yeah.
then why not make that clear in the writing so we don't get into the argument with the owner? You know, why not get it clear in the rules that are established by RICO and the legislature and the laws they provide? Have a clear understanding of all these different things, because I could go on and talk about bank statements, which have sometimes sensitive electronic routing information between owners paying electronically.
Right.
Do you really want that out in the public? And then the most common we get is, I want bids, well, the association now bidding for a repair, not the contract or the approved bid, but they want all this preparatory stuff. And we find owners then get that, they start calling the vendors and threatening them, don't you bid an act, I'm gonna sue you, your scope is the wrong scope, or whatever it may be. So I don't think those types of things should be available to owners, because it
Yeah.
creates too much trouble for the association.
Yeah, the industry practice usually is, you know, like before the contract is confirmed, those bids should be kept confidential, you know, competition, or so like it's a trade secret sometimes, you know.
Well, we're getting near the end of the show, so real quickly, what would you recommend to owners who want documents?
So I would think, you know, even if, you know, sometimes if you make a request, it could be the property manager may be on vacation, or they need to run it by the attorney's office. Sometimes there is delay. Before you go ahead and file that RICO claim, try to make another contact with the association's managing agent to follow up, you know. Don't, you know, just jump into filing a lawsuit. And also, I would think wait after the patient's waiting for that 30 days. You also got to be familiar, you know, with the law. Try to educate yourself a little bit on that to avoid frivolous claims. You know, I tend to, you know, see it in the condo living world. If everybody tends to, you know, this is probably one of the philosophy from the Analects of Confucius, talks about the principle of reciprocity. So what you do not want to be done to yourself, do not do to others.
I would also say to the board, I think the most important thing is, when you get the request, ask yourself the question, well, what's transparent to an owner? Is there any harm by giving out this information? And promptly just reply and give it to them, you know, because of the fact that if there's no harm, make them feel a part of the process, make them understand, because most boards do a diligent job with respect to their process, but we also do see exceptions where people will get into this debate, and particularly when there's money at stake and increased maintenance fees and things along that line, that information in the wrong hands, publicly distributed in the wrong way, could create liability for the board.
I
And
totally
think-
agree with that. And in the response the association provides to the owners, if they want to withhold a document, they have to provide a justification why they want to do that.
Let me thank you for being here again. It's always a pleasure to have you, because you're so knowledgeable about these issues. And I want to welcome everybody to Condo Insider again. This is our weekly show every Thursday from 3 to 3:30 on Condo Living. We look forward to you coming back next week. Aloha.
Thank you.